right. We're now streaming live.
The Supreme Court of Guam is now in session. Before I ask the clerk to call the case, I just want to apologize to the general public for the delay in starting our hearing this morning. We had some technical issues. We've sorted through those issues, and now we're ready to begin our oral arguments. Will the clerk please call the case?
Is Supreme Court case number CRA19-015 consolidated with CRA19-017 in re the People of Guam Plaintiff Appellee versus Renato Capili Bosi, Defendant Appellant. Appearing for the Plaintiff Appellee is Attorney Marianne Woloschuk. Appearing for the Defendant Appellant is Attorney David Highsmith. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Highsmith reserves 10 minutes.
Thank you. Mr. Highsmith, you are recognized.
Good morning, Mr. Chief Justice. May it please the court. This is a case which should have been simple enough. There were two allegations that the defendant brushed his hands over a young lady's private parts, but it has ended up being immensely confusing because of a lack of clarity in the record that is very troubling. It started with the indictment and the charges which repeated an element of the offense that is just completely off the mark, that says that alleged that the defendant and the victim were related when they were not. Then if we get into the charge itself farther, it says that the defendant and the victim were residing in the same household, or that that the victim was residing in the defendant's household. Something of which there was insufficient proof at trial. The victim came and went from the defendant's house. She was there on weekends for a while. She was there for a few months at a time. She, according to her own testimony on ER 258, she said that she first went to the Bosi's house in July of 2015. She testified that the two incidents happened in May of 2016, but she wasn't really sure. And nevertheless, the government persisted in charging that the abuse occurred while the victim was residing in the defendant's house. We do not agree with the prosecution's assertion that the government only argued the force and coercion element to the jury. Far from it. They mentioned the household or residential requirement several times in their closing. I asked the court to look at ER 880 and 881 and to remember that the government showed a blow up of the charges to the jury.
Mr. Highsmith, let me ask a question. But before I do that, Ms. Woloschuk, if you could mute your phone itself. We're getting some feedback from the phone. So if you just mute your phone, I think until you're wanting to speak, I think it'll prevent some of that that feedback. Mr. Highsmith, I know that you made note of the fact that it appears, and this went to a number of your arguments, the unanimity of the jury verdict. It went to the instruction, that had been given, as well as to the indictment. You seem to suggest that there were three prongs of the statute 99-2520 A2, and that is that, you know, you under the age of 14, less than 16, you're a member of the same household, or you're a position and authority over the victim and used the authority to coerce the victim. And so, but when the first prong, obviously, I think was not really at issue here, the relationship by blood or affinity. So it was just the question of whether they were a member of the same household or in a position of authority and used that authority to coerce. But why isn't those just the alternative means by which you can commit an offense? And so as those means don't constitute separate and distinct elements in and of themselves. So as long as he violates one of those prongs, it doesn't seem that, it seems that he could still be convicted of the crime because the elements would have been satisfied. Those don't seem to be distinct elements of the crime. They just seem to be the means by which the offense could be committed.
Well, they don't exactly deal with means, Your Honor. They deal with situations. Or rather, one of them does not. Residence is a situation.
But they don't constitute a distinct, separate offense. I mean, the offense remains the same.
Yes, but if the court reads 2520, there are any number of ways that the court can, that the defendant can commit that offense. There are at least 6 different subsections.
But he was only charged with A2. He was not charged, for example, with A6 under the second degree criminal sexual conduct. He was only, the only charge was a violation of 2520 A2. So, you know, it seems that the 3 prongs that are identified in A2 really just discuss the means by which the offense is committed, and in and of themselves don't constitute a separate and distinct offense. And so, you know, if 3 jurors thought he was guilty of residing in the same household, and the other jurors thought that he used his position of influence to coerce her, you know, the ultimate effect is that they found him guilty of this second degree CSC under the A2 standard. So I'm not certain that I view those as separate elements that need to be proven for purposes of the jury unanimity, and as far as your jury instruction was concerned, at least when I went back and looked at the jury instruction, the instruction that was requested at trial was more with being present at the same time and at the same place. It wasn't a question of being a member of the same household.
Yes, the court has hit on something there. But the jury, there is so much confusion over the residential element in the way it was argued to the jury and the way it was instructed by the court, that any conviction that might be based on that has to be overturned. The prosecutor argued to the jury on ER 880 that it was sufficient if the offense was committed during the period she was in the house. Now, what the defense or the prosecution was doing there was it was picking up on these old sexual abuse cases, which I have no quarrel with, that say that time is not an element of the offense, and that if, say, the charge said any time during the year 2013, the offense occurred, and the jury found that to be true, it would be true here. But here you have an argument being made on that principle to the jury, saying it was okay if it happened anytime during that period. That is not true. It has to have been done while the young lady was living in the house. That is, call it a means, call it a prong, call it an element. That has to have been found by the jury. If she living in the house at the time of the offense, and she never quite said that she was, then there has to be a reversal here. Because
why couldn't they find that he was in a position of authority over the victim and he used this authority to coerce her?
There is no, well, we're getting into another area of law there. We are saying in that argument, obviously he did not use his authority to coerce her. But, you can't just throw darts at a board and say, well, it could have been this, it could have been that. The prosecution misargued the element to the jury, and the court misinstructed the jury because it was borrowing this element, this argument holding from the old sexual abuse cases that say time is not an element of the offense, and misapplying it to this statute where time, in a sense, is an element of the offense. The defendant has to have been residing in the house at the time of the abuse, or there was no crime. If she was just there visiting, if she was just washing the dishes at the time this happened, then there was no crime under that element. And since we can't say whether the jury found him guilty under that prong or the other, there has to be a reversal because there were misinstructions and misarguments to the jury on that point.
My focus, Mr. Highsmith, if I can just move to a different issue, has to do with the fourth degree criminal sexual conduct conviction. In that conviction, he was charged, Mr. Bosi was charged under 9 GCA 2430 A1. And there, the issue is whether or not he committed sexual contact using force or coercion to accomplish the sexual contact. And you argue that similar to the second degree CSC coercion element, that since your argument it didn't exist in the second degree, it also doesn't exist in the fourth degree conviction for the same reasons. But I think there's a little distinction with the fourth degree language in 2430 A1 as opposed to 2420 2520 A2. And that is because force or coercion is defined as contrasted with coercion that is not defined in our CSC statutory scheme. Force or coercion is defined in 2430 A1, and there the under 2510, sorry, I'll call these statutory sections, but I'm sure you're very familiar with them. A2 E that defines force or coercion it has the element of surprise and that doesn't exist in the second-degree CSC coercion case law, and that's surely not in any definition. But we do have it in the fourth-degree CSC. So this is the government's contention that there was that element of surprise that distinguished the fourth-degree CSC conviction in the use of force or coercion through the element of surprise by virtue of the definition of 2510A2E. And the Ellard case is illustrative of the proof that may be necessary in proving this. And so in terms of the sufficiency of the evidence as to this element, there seems to be, and because of the nature of the standard of review, that element of surprise may exist in this case, and just in reference to how the sexual contact occurred. And so, what is your argument that is not sufficient in this regard?
Well, I think the element of surprise in Ehlert, there was genuine surreptitious behavior that the person waited till the young lady was on someone's back, I believe, and was being carried out of the water, and then sneaked up behind her and did this. In this case, we don't have the same element of surprise. We have a man coming up to a girl and touching her. Now, one thing I would like to point out is that the government argues that she was facing away from the defendant at the time this happened. That is really not clear from the record.
What is your reading of the record? Because I do note the discrepancy in the contentions.
My reading is that it's vague. She was washing dishes in one case when he supposedly touched her on the buttocks, and she described that as a hand graze over my butt. That's on ER 261. And then in 262, she seems to have been carrying dishes, and she felt his hand sweep in there and touch her front area. It would be helpful if there were more details about this in her own testimony. Once again, all we have is the girl's own testimony about the incidents themselves.
But when we look at the,
if she was carrying something, it's not, I just say it's not clear that she was facing away from him. It very well could have been, but it's really not clear from the record.
but when the evidence indicate, number one, first of all, let's look at the place where this occurred. This is in the kitchen. She was washing dishes on both occasions. On the second occasion, when there was the actual touching of her front private parts, her vaginal area, that she was seemingly going to put something back in the cupboard, and that there's one indication that he was walking in the opposite, from the opposite direction towards her, and he just swept his hands into her private area. I mean, this is not something that you would anticipate in the setting that she described. This is not something that she had some forewarning that this was going to happen. Wasn't this just something sudden that was totally unexpected, and suggests that it wasn't something that she had some forewarning that his actions of touching her in an area that she would not expect him to do so, that the facts of the case seem to suggest that those were the circumstances?
Well, we don't have an exact statutory definition of surprise. Force, I would point out the subsection E says, and I know the court can read, please forgive me. E, when the actor through concealment or by the element of surprise is able to overcome the victim. Overcome is a word that doesn't seem to apply here. He did not overcome her. He was probably, I mean, she wasn't helpless. He didn't render her helpless. He didn't overwhelm her in some way. This
But that
touching.
was true in Ellert. I mean, you know, it wasn't a situation where he overcame her. There was more the focus on the element of surprise and how he came up and engaged in sexual contact with her.
Well, I think in Ellert there was the victim was incapacitated in a sense by the position she was in. I think if I understand Ellert correctly, she had her hands around a man's neck and was riding him piggyback, and she couldn't just get off. Now, this is a little different. She was on her own 2 feet, moving around. She was not overwhelmed or overcome. The court has to decide what the element of surprise means here, and the criminal statutes must be strictly construed against the government.
So what do you suggest would be necessary? Give us an example of the element of surprise in these in the similar circumstances as what we have in the second incident here in terms of the touching of her vaginal area.
Perhaps touching her when she's asleep or waking her up. I'm trying to speculate here.
Mr. Bosi, well, how about if he came from behind her? She was faced away and he came from behind her and touched her private area. Would that be an element of surprise? And you know, she of course did not invite it, welcome it, and could be argued that he overcame her even before she was aware of what was happening.
Well, that's what the court has to decide, I suppose. Once again, criminal statutes are construed against the government. And the record's not clear that he was behind her.
I understand, but I'm saying that would that make a difference if that was if those were the facts of the case in terms of satisfying the element of surprise under these circumstances?
I suppose it might, Your Honor. But it's not clear from the record that that's what happened.
Would it make a difference if he was facing her and then came towards her and surprised her by touching her? I mean, we seem to focus on, was he behind her, was he in front of her? But when we're talking about the element of surprise to engage in or accomplish the sexual contact, does that really matter?
Well, as I have argued, if surprise is read too broadly, then every sexual assault is a surprise. Nobody really expects it. So I don't know what more I can say on that point, Your Honor.
I note that you have less than 7 minutes remaining and you reserve 10 minutes. I just want to ask Justice Merriman if she has any questions for Mr. Highsmith before we have him, if he decides to reserve the remaining time.
I'd like to ask a question to the Attorney General first, so I'm fine.
Right, so Mr. Highsmith, you want to reserve your remaining time?
Yes, I do, Your Honor.
All right, thank
Thank
you. All right. Attorney Woloschuk, you are recognized at this time.
Chief Justice and Chief Justice, and may it please the court, are you able to hear me?
Yes.
Thank you. The convictions below should be affirmed and the sentence in this case should be reformed. I would like to address some of the issues that the defendant has raised first, and then I'll get to the people's cross appeal. The first one has to do with the sufficiency of the evidence for the second degree and fourth degree CSC charges. One of the issues is, whether he was in a position, whether the defendant was in a position of authority just because he's the pastor. And I think the defense cited some cases saying that just, being a pastor is not inherently coercive. What we have different here and is cited in the cases that we have from Michigan is that it's not just that the defendant is a pastor, but it's also that a young person is involved. The person in this case was a minor. So she is under his influence.
Let me ask you a question on that. To me, I don't think that there's much doubt that Mr. Bosi held a position of authority over the minor in this case. I think the question is whether he used that position to coerce her into submitting to an act of criminal sexual conduct. And, he was charged under 25.20A2, which requires that you not only be in a position of authority, but that you use that authority to coerce the victim to submit. And what testimony did the prosecution elicit at trial that showed that this authority was used to coerce her to submit?
Your Honor, the kinds of things that you can look at to find coercion here is just the nature of the relationship that this defendant had with this victim. He had so much influence and power over her. For instance, she testified that he was suffocating her with phone calls and she felt suicidal because of that. She had to go seek treatment at Guam Behavioral Services. He was telling her how to dress, who she could date, what she could do. Just he had so much control over her life that even the first time she doubted herself when he touched her inappropriately, she thought it might be an accident. And it's only when it happened the second time that she realized the first time was no accident. These are coercive measures that he was using. He'd been just exerting influence over her and using that in order to, get one over on her so that he could do these acts, engage in these acts of criminal sexual conduct.
Yeah, but Ms. Woloschuk, in Tenorio, we considered and we squarely rejected the inherent coercive relationship in and of itself being sufficient to satisfy the coercion element. And I think, Tenorio says you have to have more than just the relationship. In that case, I guess it was a club. It was a relationship with a social club supervisor over one of the kids attending this overnight stay. And so in this particular case, you're saying just because he is a pastor and the fact that she is a member of the church, and that for some reason or that in and of itself is sufficient to satisfy the coercive element, and we rejected that in Tenorio.
I think it's not just that alone, Your Honor. There's also the fact that her parents have entrusted her to this defendant, whereas in Tenorio, that was not the case. It was an adult victim and it was a youth leader, whereas here, it's somebody who's supposed to be taking care of her. In the meantime, she's got a father who's very sick. She's got a mother who's off island. She's having problems with them at home. And here is a defendant who is taking advantage of that and using his authority to be able to engage in these acts of sexual misconduct.
Yeah, I just think there's something missing there in reference to the specific charge under 2520A2 and using that authority as just as Torres has stated to coerce her. And you know, let's speak specifically as to the facts of the case in reference to the incident, most probably specifically in terms of the second incident of occurring in the kitchen. What does that authority have to do? I mean, she didn't testify that as a result of him being the pastor, I was forced to submit. He was, there was absence of testimony that from the victim that as a result of Mr. Bosi's position as a pastor, she felt threatened. She was thought that it would have been wrong to submit because something negative would have happened. So there was no testimony whatsoever. So as I see it, all that you're left with in terms of arguing is just the relationship of being pastor and a member of the church who is being cared for at times by the pastor and his family. And there was no testimony on her part that because of his position as the pastor, she in some way felt that she had to submit to this sexual contact that is alleged in this case.
Your Honor, even if there's no testimony specifically from the victim, there is testimony from other witnesses. For instance, you know, the reason she is staying with this family is so that they can impose discipline on her. The defendant gives her chores to do. He tells her how to dress. You know, he tells her that she can't date someone. There's going to have to be a public apology about some of her conduct. These are things that he can use, you know, to control her. So even if she didn't testify to that, other people did. These are things that other people said were happening at the time. So I think you can find that he exerted his authority over her to force her to submit to his coercion.
Yeah, but you don't have testimony from any of these others that she was constrained or compelled or unable to react as her free will would dictate when the touching occurred, right? None of them talked about that. I mean, they just discussed the position of authority. What I think we're missing is the link that's required under 25.20A, how he used that authority to coerce her to submit to the act of the criminal sexual conduct for the second degree.
Your Honor, I think the fact that she didn't even react and she kind of froze when these things happened and even thought it was an accident at first and then realized that it was something true, that these are things that show that he had an influence over her and that he was you know, going to exert his will. And, you know, there are also the fact that he would show up at her house when she's there alone, when he knows her parents aren't there. just the fact that he's constantly contacting her, he's sending her emails, he's telling her to delete the emails from him, he's asking her to keep secrets. These are all the types of grooming, coercive activities that these types of defendants engage in. And I think that's how you can find the link for between the authority that he has in his position and the coercion that he uses to make her submit to his will.
But Ms. Wallachuk, the time elements are also important here. You just seem to splatter all these circumstances, but the incidents occurred in May of 2016 in reference to the incident about him visiting her unexpectedly and making these purchases. That occurred in August of 2016. So these were subsequent acts to the incident being charged here. And so how do you link that at the time that occurred, she felt coerced by just suggesting those circumstances exist when those things happen subsequent to the alleged touching in this case, the touching in this case?
Your Honor, I'm not so sure we can say that they were subsequent because the victim was not positive about the timeline, and that's one of the reasons. Yes? Oh, the victim was not positive about the timeline, and she even mentioned things about how something happened when he came back from the Philippines, and he testified that he never even went to the Philippines at that time. So I don't think that the victim here had a good handle on exactly when things happened. I think that you can use the totality of the circumstances to find that there was the authority that was used to coerce her.
Well, I don't know necessarily if it's vague and you can't pinpoint the times that you can then say that, that's sufficient evidence in reference to supporting the coercion separate and apart from the fact. And I as just stories point out, I don't think there's a question as that, he was the pastor and that he had authority in that regard, but did he use that authority to coerce her into these sexual, unwanted sexual contact?
Can we talk about some of the evidence in this case? I'm a little troubled by the authentication of the email evidence in this case. Clearly there is a requirement of authentication and as a condition precedent to admissibility. And normally you do so through, the testimony of a witness who has knowledge that it's what it claims to be. And then you can also do it through other ways, and particularly with email with, some, specific appearance, contents, or identifying matters. Here, it appears that in this case, the Bosi denied that he was the one who authored the email, and there was no witnesses who said they saw him compose it or send it. And the only person that it seemed had come forward to provide authentication was the father of ADG. But he didn't have personal knowledge that the emails were what you claim they were. So how is it that you could suggest that these emails were appropriately authenticated? What steps did you take to authenticate them?
I think, Your Honor, we can look at some of the other testimony that was there in this case, and the fact that we have these emails and we can read them and we know what they say So the emails, are said to be sent from the defendant to the victim. He tells her to delete all his emails. She keeps some of them. She forwards them to her sister, who sends them back to either her mother or her father, and that's how he gets a hold of them. And then there's a meeting between the defendant and the victim's father and Pastor Puckett. And Pastor Puckett confronted the defendant with these emails, and he said what was in them. I think he talked about, you should delete everything, and the defendant told him, oh, that's for cybersecurity. But Pastor Puckett says he's been in the military and he knows that's not true. And then he confronted him about the email that said something like kissable lips, with the kissing emojis. And Pastor Puckett said that's not appropriate. And the defendant, said, well, that was meant sarcastically. That was not something, that wasn't a serious email. So the defendant admitted that these were his emails. So, we may not have an image of them before, we may not have an image of what Pastor Puckett was looking at, but from the description, they sound exactly like the ones that the father is talking about. So I think taken together under the circumstances, we can authenticate the emails that way.
And then the other piece of evidence is the spandex. If you look at the spandex, the argument is that the court should not have admitted the spandex because of the discovery violation. And if you look at the test that we adopted for purposes of whether the Hinton test, I think the first prong of that test, that proving a material element of the crime charged, I don't think that seems to be a big issue. I think you could meet it by saying it shows maybe intent to commit the CSC. The third and fourth prong of those tests, also don't appear problematic. But that second prong, the prong that says it's similar to the charged conduct, it's not so clear to me that the evidence of the spandex is sufficiently similar to the criminal sexual conduct. I mean, of course, there's an allegation there were some sexual undertones to giving it, but there's also a possible theory, as they talked about, that the reason that gift was made was for purposes of promoting modesty. So, in terms of the analysis of that, I think it's a little bit closer call as to whether the spandex should have been admitted. And what are your thoughts on that?
The defendant, Your Honor, did have an opportunity to present his view of what the spandex meant. He was saying that his wife buys spandex for all the girls. It's not a big deal. It's just for them to be modest. But in this case, he actually bought the spandex himself for the victim, went to his house by himself when he knew she was alone to give it to her. And then he told her, don't tell my wife about this or your mom and dad. So he was trying to keep a secret, and it sounds like grooming activity. It's classic grooming activity, giving somebody something with these, intimate undergarments, with sexual undertones. And I think it does have to do with the charged conduct. It may not be exactly the same, but it's similar enough that it should have been admitted, and it was. It was properly admitted, and I don't think it was error for the trial court to admit it in this case. I think that was okay.
Thank you. Ms. Foley,
the other thing,
with
yes, Your Honor.
this spandex, it seems like there was a serious discovery violation. Why shouldn't the court have sanctioned the government by not allowing the spandex to be introduced, given the discovery violation?
I would not say that there was a discovery violation here. For one thing, our rule requires the defendant to request these types of things in advance. And so I think I'm not sure if that was included in their discovery motion because I didn't see a copy of it, but that's one thing that they would have had to do in order for this to be some sort of discovery violation by the people. But then another reason this isn't a discovery violation by the people is because the people only just found out about it at trial, and then they scrambled as quickly as they could to produce it. I'm sure if they had not produced it, then the defendant would be complaining about that. He's already complaining that the people did a poor job of preparing their witness. But, you know, sometimes victims just aren't ready to talk about something until they are ready to talk about it. And I don't see how you can force somebody to tell you something when you don't even know yet that it exists. So we would argue, Your Honor, that there was no discovery violation in this case, and the government shouldn't have been sanctioned, and this evidence was properly admitted. I wanted to turn now to the unanimity issue. I think Your Honor's asked the defense a lot of questions about this and brought out that it's okay to charge this way. He was charged and instructed in the disjunctive, and there are three means and manners of committing this type of offense. And I just wanted to point out that in the closing argument, the people were focused on the coercion and authority. They even said, this is the key. This is the key. So they were not saying that the household element was what they were going for. The people elected the authority and coercion manner of committing the offense. And you can tell that these are not elements because the offense, in order to commit that offense, you have to have sexual contact with somebody of a certain age, and they have a certain type of relationship, and it could be one of these three types of relationships. And it doesn't really matter which type of relationship. If it's somebody who's in the household versus somebody who's related, the offense has still happened. It's not a different kind of offense, and so therefore there was no violation of unanimity, and so those convictions ought to stand. I'm going to turn now to the sentencing issue because we cross-appealed that because the trial court judge in this case reduced the degree of the offense. He reduced the second-degree criminal sexual conduct charges to fourth degree, and then he sentenced accordingly. And I think to arrive at that result, he did not give proper concern to the victim's age. I think he disregarded the victim's age, and he was supposed to consider the nature of the offense and not just the history of the defendant and his character and stuff, but he was also supposed to consider the nature of the offense. And part of that has to do with the fact that there was a very young person involved here. It was somebody who was 14 years old. And we think that the trial judge in this case abused his discretion because he sort of disregarded her age and reduced the offense. And I think he was swayed by the character and the history of this defendant. And so we would ask the court to reverse that decision that the lower court made and remand the matter for resentencing. But we also ask that the court affirm all the convictions below. Thank you.
How could you assert that the trial court ignored the victim's age in making a determination under 80.22 when, there was also the child abuse charge and the court sentenced him on a child abuse charge and sentenced him to 8 months of incarceration on a child abuse charge. So in the judgment itself, it seems to suggest that the court is clearly understands that there was a child involved here.
Yes, Your Honor, and that's why the trial court was being inconsistent. It recognized that she's a child for purposes of the child abuse statute, which is just a misdemeanor. But when it comes to felony charges, suddenly it doesn't really matter so much anymore, and he can reduce the degree of the offense from second degree to fourth degree. So that's why we're saying what we're saying. And that's why we're asking the court to reverse that decision and remand for sentencing. And I think I had something in my brief. I think I said that the sentence was 15 to 20 years for that felony, the first degree felony for a second degree CSE. For a first time offender, it's actually 3 to 15. So it's even lower than what I said in the brief. So I just wanted to point that out as well. Thank you.
Yeah. Ms. Wallace-Chuck, I would note that at the continued sentencing hearing, when the court was discussing its rationale for reducing the sentence, the court did note, and this is on page 79 of your supplemental excerpts of record, that this occurrence was perpetrated against a minor 14 to 16, and it's significant and goes through a discussion of why children should deserve the protection of adults and goes on and on. So I don't find that the fact that the court ignored the age of the minor in its consideration of the factors of the offense and the history and the character of the offender in deciding to enter judgment for a lesser included offense.
Let me just say,
oh, sorry.
I just want to add that in addition to that continued sentencing hearing, the trial judge in this case, in applying 80.22, made a finding that number one, the sexual touching was made over and not under ADG's clothing, that the contact occurred in an open space as opposed to a secluded area, that the sexual contact could be characterized as slight, and then adds that there was considerable testimony that Mr. Bosi, the pastor, had a positive effect on the community. And so it would seem to suggest, in addition to what was pointed out by Justice Torres, that the trial court in the continued sentencing hearing was very aware of the standards and cited to facts that it seemingly wanted to point out to support the court's subsequent reduction of from second degree to fourth degree in the corresponding sentencing in terms of the fourth degree charge or offense. So wouldn't that indicate that there was a conscious effort on the part of the trial court to apply the standards of 80.22 in reference by pointing out these facts?
Yeah, yes, Your Honor. I just looked at my notes, and I shouldn't have said he ignored her age and all these other factors. I should have said he discounted them. I don't think he weighed them properly. He seemed to give more weight to the defendant than he did to the offense. And I think it should have been more balanced. And if it had been more balanced, then it wouldn't have come out this way. I don't think that the rationale supports the result here, and that's why the people are asking the court to reverse that decision and remand for sentencing.
Before I'd like to extend to Justice Merriman, because she said she had some questions for the prosecution, before I ask you my last question on this issue.
Justice Torres asked the questions I had.
All right, so in reference to the cross appeal, if assuming that the second degree CSE conviction was reversed, and so the greater offense conviction is vacated, then I assume correspondingly under People versus Jones, there would not the court could not then sentence on the lesser included offense as opposed to the reduction on the second degree CSC. And I note that the trial court did not issue a specific sentence on the separate fourth degree CSC conviction. So, what's your view in reference to what's the remedy, assuming that the court vacates on the insufficiency of the evidence argument Mr. Highsmith makes on the lack of coercion to support the second degree CSC conviction?
So Your Honor is asking if, what if the lower court grants like a general?
No, I'm saying that assuming the Supreme Court reverses the second degree CSC conviction and vacates that conviction. So to me, that suggests that the reduction of sentencing on the fourth degree would similarly be vacated because the greater offense conviction, assuming it's vacated. And so what we're left with is only the fourth degree CSC conviction. And assuming that's affirmed that there was force or coercion, so number one, do we even get to this issue of your cross appeal? And number two, what remedy would the court pursue if those were the circumstances where my reading of the judgment is that the trial court did not issue a specific sentence as to the fourth degree CSC conviction, the actual conviction as opposed to the reduced second to fourth degree.
Yeah, the trial court in that instance only said that any sentence for the 2 counts of fourth degree are going to merge with the sentences above, but didn't pronounce a specific sentence, as the Chief Justice indicated, for those fourth degree CSC.
Okay, yes, Your Honor. I think if I understand you, you're saying that, what if the second degree CSC is vacated? Okay, so he's considered acquitted of that. Then your honors are correct. The cross appeal doesn't, there's no decision to undo there because you will have taken a completely different tack. In that case, though, the fourth degree convictions remain, and he can still be sentenced on those. Just the fact that they merged with that sentence doesn't mean that he can't be resentenced on them. He should be able to be resentenced because he's been convicted.
So the remedy is to refer it back to the trial court for resentencing, since there was no specific pronouncement by the trial court as to the fourth degree CSC conviction, a separate conviction.
Yes, Your Honor. That's what we're saying. Yes, thank you.
All right. I have no further questions.
I have one other question on the sentencing issue, and I wanted to understand a bit further the argument. You made an argument that, and I guess if the second degree CSC is vacated, the conviction, then this would be moot, or wouldn't be an issue. But you indicated that a person who was convicted of second degree CSC could not be sentenced as a first offender and had to have a mandatory minimum sentence of 5 years. And therefore, is it your position that the trial court, in looking at 9 GCA 8.22, would be barred from imposing a sentence for less than the mandatory minimum for the conviction, even if it treats it as a lesser included offense, as the trial court did here?
Your Honor, I think I said earlier that the minimum is going to be 3 years. It's going to be 3 to 15 for a first-time offender. The first-time offender statute does apply in the case of second-degree CSC. It does not apply to first-degree CSC, I believe. So whatever the sentence is in that first-degree CSC statute, that's what you have to give, whereas the second-degree CSC statute says that it's a first-degree felony, and so you're supposed to sentence someone who's convicted of that as someone who's been convicted of a first-degree felony. And if you go to the statute for sentencing someone as to a first-degree felony, you see that the range is, 5 to 20, and if you're a first-time offender, it's 3 to 15. So I think in this case, if the defendant doesn't have any other convictions, he would be a first-time offender, and he would be eligible for the 3 to 15.
Right, but how does that interact with the 9 GCA 80.22? Can the trial court still make those considerations under 80.22 and depart from the prison term for first offenders found in 80.31, or you're saying that he cannot?
Oh, Your Honor, we're saying that if he's going to reduce the degree of the offense, it has to be without abuse of discretion. We believe that there was abuse of discretion in this case, and that's why we cross-appealed it. If there's a resentencing and there's like a really good reason that he gives for doing what he does and for imposing the type of sentence that he does, then we would accept that. It's just that in this case, we don't think the circumstances were acceptable, and that's why we cross-appealed the issue.
Okay,
Thank you.
I read your brief, and I'll go back and look at it again, as saying that he was barred from even being able to reduce it beyond the first offender guidelines under this provision, that somehow that influenced it. But that's not your position.
No, that's if he were to resentence and it was done within the bounds of his discretion, that is something that we could accept. It's just that in this case, we think there was an abuse of discretion. We think that he discounted the victim's age and the circumstances of the offense. I think he really minimized what happened here and the effect that this offense had on the victim in this case. And so that's why we don't think this was an appropriate thing to do here, to reduce the degree of the offense and then give a very, very brief sentence considering what was done to this victim. Thank you.
Thank you, Ms. Wallachuk. You're over your time, and so at this time, I'll ask Mr. Highsmith to complete his argument.
Thank you, Your Honor. I have about half a dozen points that I'd like to make very quickly.
All right.
On the sentencing issue, the government's complaint seems to be that the court weighed traditional sentencing factors in the wrong way, that he gave too much weight to the defendant's past history, having built churches and served as a pastor, in not the harm done to the victim. But those are traditional sentencing considerations. They are usually left up to the trial court. The appellate courts are loath to set those aside. As counsel has indicated, the standard is abuse of discretion, but it's very unusual for an appellate court to say, well, as long as even though the trial court kept it between the lines and didn't violate any statute, we're going to reverse what happened because it was an abuse of discretion. Once again, we disagree with the argument that the prosecution concentrated on unanimity in its argument. It may have mentioned it once or twice more, but the arguments about residents in the same household were made. And there's this blow up shown to the jury that stated all of the elements or means of committing the offense, whatever they are, and the judge repeated them in his closing. The spandex is indeed not sufficiently similar to the activity. It is very dubious that it could be considered grooming. Spandex is underwear worn over underwear. It's not really sexy stuff. And there's
so, Mr. Highsmith, did it have any probative value?
The problem with 404B is that sometimes evidence has the wrong kind of probative value. It shows propensity. And that's what the government used this underwear to prove, is that this man is a dirty old man. Look, he buys underwear for young girls. And in other words, it proved the wrong thing. It proved a propensity to do something rather than a tendency to commit rather than intent, motive, plan, or what have you. And we're not even sure that the spandex was purchased before the incidents. It's if I can be indelicate for a second, it would seem a little self-defeating. Someone who's going to touch a young girl's private parts wouldn't buy her an extra layer of underwear. It makes no sense. On these discovery violations, in that point, counsel says, she talks about the rules. Well, there was a discovery motion. More importantly, there was a discovery order that required the prosecution to present and give to the defense everything before trial. That was violated. And I suggest that that's very significant here, that the prosecution did not find this evidence until it happened. It could have easily let everything go at trial. The girl mentioned the spandex in her testimony for the first time. Let me see, that's
But isn't it within the trial court's discretion to,
264. I'm sorry.
isn't it within the trial court's discretion to determine whether they exclude or not exclude the spandex for a discovery violation? I mean, you went through this whole analysis about evaluating it under the TUNCAP factors, you know, but those factors are when a court imposes sanctions and in determining if the sanction's too harsh. Here, the court, you know, did not exclude the evidence. So I didn't see any authority that you cited that a trial court's decision to not impose an exclusion sanction is beyond his discretion.
Well, exclusion, of course, is a sanction. It would have been so easy just to exclude this evidence, simplify the trial, and let the case go on with the facts.
But it didn't do that. It decided it didn't want to exclude that evidence. And so, you know.
We have problems with 404B, I think, that have been well stated. There's a problem with 403. The evidence is far more damaging than probative. It doesn't, its probative value is very slight. And as I have indicated, it proved the wrong thing. It proved tendency or propensity. It didn't prove intent, plan, motive, or what have you. And that's where the abuse of discretion comes in.
I want to go back to, before your time is up, one question about the sentencing issue. You seem to make the argument that the court didn't rely upon 80.22 when it reduced the second degree CSC to a lesser included offense of fourth degree. And you seem to suggest that the court was acting pursuant to a different statute and actually acquitted the defendant of the second degree CSC, and that the court was acting pursuant to 90.25, which provides for a reason, if there's a reasonable ground in doubt, he will only be convicted of the lesser degree. But the court, in nowhere did I see that the court referenced 90.25. The court, seemed to just go through the analysis of what was required under 80.22, 9 GCA 80.22.
I understand. once again, I think the record's confusing. I think to make sense of what the court did, we have to look at 90.25. It's just a given. I think every judge understands, every defense and prosecution lawyer understands that if the proof fails on a greater offense, it can be there can be an acquittal and you proceed on a lesser offense. And that's what I think happened here. If you look at supplemental excerpts of record 78, 79, the judge's reduction was based on facts. He considered the facts. And I point out that the judgment says that the court denied the motion under the leniency statute and granted the other motion for reduction of the offense. So this was a judge's decision based on the facts to reduce the level of the offense.
But the judge denied the motion for acquittal, and are you saying that the judge reweighed the sufficiency of the evidence here?
Yes, I think that's what he did. It's apparent in his comments. It's apparent in the decision. And remember, as Kanata points out, what the judge calls acquittal or it doesn't call an acquittal is not always determinative. An acquittal, the prosecution argues acquittals don't happen by accident, but they can happen any number of ways, even if they're wrong, they bar retrial. So if I can say one thing about the Kanata decision before I go, retrial does not seem to have been an issue in Kanata, and I think that's crucial to rereading and interpreting the Kanata decision about double jeopardy. Thank you, Your Honor.
I have one last question. Mr. Highsmith, in your pleadings, you asked for acquittal on all charges, but I didn't hear you discuss or brief the child abuse charge.
Well, I don't have the same kind of arguments on that charge. I don't argue that there was a lack of proof or a lack of an adequate jury instruction or a misplaced argument. Really, the only arguments that apply to the child abuse argument are the evidentiary ones about the spandex and the emails. I hope that answers Your Honor's question.
Yeah.
All right.
Thank you.
Thank you. Thank you, Justice Merriman. Thank you, counsels. Mr. Highsmith, your time is up. So the court will take the matter under advisement, and the court now stands adjourned. Thank you, counsels, for your time and your patience. And we got through it, Ms. Wallace-Chuck, so we're good. Thank you.
Thank you, Your Honor.
Thank you.
Goodbye.
All right.
Goodbye.
All right, justices. Thank you.